I have heard insults in my courtroom before. I have heard defendants' questions on my rulings, my patience, my intelligence, and sometimes even my humanity. But there was one morning when a woman named Karen Whitmore sat across from a struggling single mother, smirked at me from behind her designer glasses, and mocked something deeply personal about my age. She thought it was funny. She thought the courtroom would laugh with her. She thought humiliating a judge would make her look powerful. What Karen did not understand was that the file sitting in front of me contained one clause, one signature, and one email that would cost her $50,000. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a woman named Sarah Collins, 36 years old, small business owner, mother of two. She walked into my courtroom with a folder clutched tightly against her chest, the way people hold documents when those papers represent more than money. Across from her sat Karen Whitmore, 44 years old, expensive blazer, perfectly styled hair, large handbag placed on the table as if it were part of her legal argument. Karen looked relaxed, too relaxed. Years on the bench teach you that calm can mean two very different things. Sometimes comes from truth. Other times calm comes from entitlement. Karen had the second kind. The dispute involved a boutique event planning contract. Sarah claimed Karen hired her company to organize an anniversary gala at a luxury hotel. The agreement was signed, vendors were booked, decorations were ordered, and Sarah's team worked for nearly 6 weeks preparing the event. Then Karen canceled, not months before the event, not weeks, 48 hours before. Sarah claimed the contract required Karen to pay a cancellation fee of $50,000 because non-refundable vendor deposits had already been committed. Karen claimed the cancellation fee was unfair. At first, that was the case. A contract, a cancellation, a fee. Sybil, at least, that is what it looked like. I asked Sarah to explain what happened. She stood carefully and began speaking. Your Honor, Miss Whitmore signed the agreement on April 3rd. We reserved the ballroom, hired the florist, secured catering, lighting, entertainment, photography, and staff. Karen interrupted immediately. She makes it sound dramatic. I looked at her. Ms. Whitmore, you will have an opportunity to speak. I'm just saying she's exaggerating. You will have an opportunity to speak. Karen leaned back and rolled her eyes. That small gesture told me a great deal. Respectful people may disagree. Entitled people perform disagreement, Sarah continued. She explained that the event was for Karen's 25th wedding anniversary. Karen wanted a dramatic entrance, custom floral arches, live music, branded menus, and a luxury dessert station. Everything had been approved in writing. Everything had been scheduled. Then, 2 days before the gala, Karen sent one short email, "Call cancel everything." Sarah said she called Karen immediately. Karen did not answer. She emailed. Karen did not respond. She texted. Nothing. By the time Karen finally replied, vendors had already confirmed that most deposits were non-refundable. I turned toward Karen. Why did you cancel? She shrugged. We changed our minds. The courtroom became quiet, not shocked, just attentive, because that answer was much too casual for a $50,000 dispute. You changed your minds? Yes. 48 hours before the event, that's when we changed our minds. Was there an emergency? No death in the family? No. Medical issue? No. Problem with the venue? No. Problem with Miss Collins's performance? Karen paused. That pause mattered. Then she said, there would have been. Interesting. Very interesting. Not there was. There would have been. People often reveal weak claims through future tense. I leaned forward slightly. What does that mean? Karen crossed her arms. It means I could already tell she wasn't going to deliver. Sarah looked stunned. I watched her closely. Her reaction did not look rehearsed. It looked wounded. There is a difference. I asked Karen for evidence, iMom's photos, complaints, vendor issues, anything showing Sarah failed to perform. Karen had nothing, no written complaint, no missed deadline, no vendor warning, no proof, only attitude. Then Sarah handed me the contract. I reviewed it carefully, page 1, page 2, page 3. Then I found the cancellation clause, clear but bicentennial. If cancellation occurs within 7 days of the event date, client remains responsible for all committed non-refundable vendor costs and a fixed cancellation fee totaling $50,000. I looked at Karen. You initialed this clause. She smiled. I initialed a lot of things. That answer bothered me. Not because people do not read contracts. Many do not. But because Karen said it as if carelessness were a defense. It is still your signature, I said. Karen sighed. And then it happened. She looked directly at me, tilted her head, and laughed. Not at the contract, not at Sarah, at me. Well, maybe this is just a menopause mood swing, but you're taking this way too seriously. The courtroom froze. Sarah's eyes widened. The spectators stopped moving. Even the court officer looked toward Karen as if he could not believe she had said it. I sat still, completely still. Because years on the bench teach you that when someone exposes their character publicly, the smartest thing a judge can do is let the silence finish the sentence. Karen smiled for half a second, then realized nobody was laughing. And that was the first time I saw fear enter her face, because she had not just insulted me, she had revealed the same contempt that appeared in her emails, her contract behavior, and her treatment of Sarah. I looked down at the file again, and that is when I noticed one document Karen clearly hoped I would never read aloud. The silence after Karen's comment lasted only a few seconds, but believe me, it felt much longer. Years on the bench teach you that people often reveal their entire character in a single sentence. Karen had just done exactly that, not because she insulted me. Judges hear insults. That comes with the job. What interested me was the mindset behind it. Karen believed that if she could make someone feel small, their argument would become smaller too. People like that rarely understand how courtrooms work. Facts do not become weaker because someone behaves badly. If anything, the behavior usually makes the facts more visible. I looked back down at the file. The document that caught my attention was an email, nothing dramatic, no bold language, no legal threats, just an ordinary email, the kind people send every day, and those are often the most dangerous. Because people are careless when they believe nobody important will ever read their words. Karen apparently believed exactly that. I opened the email. Then I read it again, and then a third time. Because I wanted to be certain, I looked up Ms. Whitmore. Karen crossed her arms. Yes? Did you send this email? Immediately, her confidence shifted. Not completely, but enough. Years of courtroom experience have taught me that confidence often weakens before the person realizes it. Yes, the answer came slower this time. Interesting, very interesting. I held up the document. This email was sent 5 days before you canceled the event? Yes. And you wrote it? Yes. I began reading. Sarah, everything looks amazing. This is exactly what I wanted. The room became quiet. Sarah said nothing. Karen stared at the table. I continued. My husband is going to be blown away. Interesting. Very interesting. Because moments earlier, Karen suggested she already knew Sarah would fail. Now we had written evidence proving the exact opposite. I looked directly at her. 5 days before cancellation, you praised the work. Karen shrugged. I changed my mind. Interesting answer, not a convincing answer, but an interesting one. because people are allowed to change their minds. The problem is that contracts often survive those changes. I continued reviewing the records. Then I found another email, and another, each one praising the event, each one approving details, each one making Karen's position weaker. The spectators were noticing it too. You could feel the mood shifting. Karen sensed it. That was when her attitude changed. Not dramatically, subtly. She stopped smiling, stopped leaning back, stopped appearing relaxed. People become less comfortable when documents start speaking for them. Then I found something that genuinely caught my attention. A message sent the night before cancellation. Interesting, very interesting. The timing alone made it important. I opened it, read it, then read it again because suddenly the entire dispute looked different. I looked toward Karen. Did you send this text message? A pause, then, yes. The courtroom became silent. I read it aloud. Don't tell Sarah yet. Let's wait until the deposits become non-refundable. Nobody moved. Nobody spoke. Even Karen remained silent because there it was. Not frustration, not dissatisfaction, planning. Documented planning. Sarah slowly lowered her eyes. The spectators exchanged shocked looks. I remember watching Karen very carefully at that moment. Years on the bench teach you that people react differently when caught. Some become emotional, some become defensive. Karen became calculating. That fascinated me because she wasn't looking for the truth. She was looking for an exit. Then I continued reading. The message wasn't sent to Sarah. It was sent to someone else, someone named Rebecca. Interesting. Very interesting. I checked the records. Rebecca Whitmore, Karen's sister. That mattered because private conversations often reveal motivations public statements hide. I continued. The next message read, if I cancel after Friday, she can't reuse most of the vendors. The room became completely silent. Sarah covered her mouth. The spectators stopped moving. And honestly, even I found the wording disturbing because it suggested knowledge, not confusion. Knowledge. Karen knew exactly what would happen financially. She simply didn't care. That observation stayed with me. A lot. Then I looked toward her. Why would you wait until deposits became non-refundable? Karen immediately answered. That's not what I meant. Interesting, very interesting. Because innocent people usually explain meaning, Karen only denied implication. That difference matters. I asked her to explain. She couldn't. Not clearly, not specifically, not convincingly. Then I found another message. This one was sent only minutes later. And the moment I saw it, I knew Karen was in trouble. Real trouble. I read it once, then twice, then a third time. Because the language was extraordinary. I looked toward her. The color had already begun disappearing from her face. That reaction told me plenty. Did you write this? A long pause followed. Then, yes, I began reading. She'll never spend 50 grand fighting me in court. The room froze, Damel silence. Nobody moved. Nobody spoke, not even Karen. Because suddenly the cancellation fee wasn't the center of the case anymore. The center of the case was motive, and motive changes everything. Years on the bench teach you that contract disputes often become easier once motive appears, because people stop arguing about paperwork and start revealing intent. Karen's own words suggested she never expected Sarah to fight back. Interesting, very interesting. Then I noticed something else, a name appearing repeatedly throughout the messages. Not Rebecca, someone else, a man named Christopher Whitmore, Karen's husband, the husband whose anniversary event had supposedly been canceled by mutual decision. That caught my attention immediately because every message referenced him, yet according to the records, Christopher had never participated in the cancellation. Not once. I reviewed the thread again. And suddenly one question became impossible to ignore. Did Christopher even know Karen canceled the event? I slowly looked up. Karen saw the expression on my face, and for the first time that day, she looked genuinely worried because she knew exactly where I was about to go next. The moment I started focusing on Christopher Whitmore, Karen's entire demeanor changed. And believe me, that told me more than any argument she had made all morning. Years on the bench teach you something important. People rarely fear questions unless they already know the answers are dangerous. Karen had no problem discussing contracts. She had no problem discussing cancellation fees. She had no problem insulting people. But the instant her husband entered the conversation, fear appeared. Real fear. I reviewed the message thread again. Then I looked toward Karen. Did your husband know you intended to cancel the event? The room became silent. Karen hesitated. Interesting. Very interesting, because this should have been an easy question, a simple yes or no. Yet she looked like someone choosing between bad options. Finally, she answered. Of course. Interesting answer. Not convincing, but interesting. I looked down at the records again. Then I found something that immediately caught my attention. The anniversary gala was supposedly being organized for both Karen and Christopher, yet every email came from Karen. Every approval came from Karen. Every instruction came from Karen. Every cancellation came from Karen. Christopher's name appeared only as a subject of discussion, never as a participant. That bothered me a lot, because people planning major anniversary celebrations usually communicate, especially when hundreds of guests and tens of thousands of dollars are involved. I turned towards Sarah. Did you ever speak directly with Christopher Whitmore? Sarah answered immediately, no, Your Honor. Phone calls? No. Emails? No. Meetings? No. Interesting, very interesting. The spectators noticed it too. The room felt different now, less like a contract dispute, more like an investigation. Karen sensed it, and she hated it. That much was obvious. Then I found another document, a very interesting document, the guest list. I reviewed it carefully, then again, because one detail stood out immediately. Several guests had handwritten notes beside their names. Interesting, very interesting. Most were ordinary planning notes, dietary restrictions, seating preferences, arrival details. Then I found one note next to a guest named David Mercer. The note read, "Do not seat near Christopher." The room became quiet. I stared at the notation for several seconds. Because it wasn't the type of note event planners usually create themselves, someone had requested it. I looked toward Sarah. Who gave you this instruction? Sarah immediately answered. Karen. Interesting, very interesting. Karen looked away. That reaction mattered because she already knew what was coming. Years on the bench teach you that people often react before questions are finished. Guilt tends to arrive early. I turned toward Karen. Why should David Mercer not sit near your husband? A long silence followed, then, it wasn't important. Interesting answer. Very interesting answer, because people rarely create special seating instructions for unimportant reasons. I asked again. Karen became visibly irritated. I don't remember. Another interesting answer. People often forget details that become inconvenient, yet somehow remember details that help them. That pattern rarely improves credibility. The spectators were beginning to notice the contradictions. So was Karen. That was why her answers were becoming shorter, less confident, more defensive. Then I found another email. And honestly, the moment I saw it, I knew the case was about to change completely. The email wasn't sent to Sarah. It wasn't sent to Rebecca. It wasn't even sent to Christopher. It was sent to David Mercer. Interesting, very interesting. The timing immediately caught my attention. The message was sent less than 24 hours before the cancellation. I read it once. then twice, then a third time. Because I wanted to be absolutely certain, I looked toward Karen. The color disappeared from her face. Immediately, that reaction alone told me the email mattered a lot. Did you send this message? Silence. Then, yes, the courtroom became silent. I began reading. Everything is almost ready. Christopher still doesn't suspect anything. Nobody moved. Nobody spoke. Sarah slowly lowered her head. The spectators exchanged stunned looks, and suddenly the anniversary gala looked very different. Interesting, very interesting, because now we had a secret, a documented secret. One Karen apparently didn't want her husband discovering. I continued reading. The next sentence made the room even quieter. After the party, everything changes. Silence, silence. I remember watching Karen carefully. Years on the bench teach you that people often reveal future intentions when they feel safe. This email was written when Karen felt safe. Now she wasn't. And she knew it. I looked toward her. What changes after the party? Karen immediately answered. Nothing. Interesting, very interesting, because her own email suggested otherwise. I asked her to explain. She couldn't, not clearly, not logically, not convincingly. Then I found another attachment, and this is where things became truly strange. The attachment wasn't related to flowers or catering or entertainment. It was a financial document, a very detailed financial document, and according to the metadata, it had been shared between Karen and David Mercer. Interesting, very interesting. The room became completely silent as I opened it. I reviewed the first page, then the second, then the third. And suddenly, I understood why Karen had become so desperate, because hidden inside that document was information Christopher Whitmore was apparently never supposed to see. Information worth far more than $50,000. Information that could destroy an entire marriage. I slowly looked up. Karen was staring directly at me, terrified. Not nervous, not embarrassed. Terrified, because for the first time all day, the secret wasn't hers anymore. I remember the exact feeling that hit me when I opened the financial document. It wasn't surprise, not immediately. It was curiosity, because years on the bench teach you that people rarely risk everything to hide something small, and Karen had been risking a lot, her credibility, her case, her reputation, possibly even her marriage. People do not usually take those risks unless the secret is significant, very significant. The courtroom remained silent. Karen watched me. Christopher Whitmore watched me. Sarah Collins watched me. Even the spectators seemed to sense that something important was about to happen. I reviewed the first page carefully, then the second, then the third, and the more I read, the more troubling the picture became. Interesting. Very interesting. The document wasn't a business proposal. It wasn't an investment report. It wasn't an anniversary budget. It was a financial planning worksheet, one prepared by Karen and David Mercer. And Christopher's name appeared throughout it, repeatedly. That immediately caught my attention. Because Christopher wasn't listed as a participant, he was listed as a variable. A variable, years on the bench teach you that language matters. People reveal how they think through the words they choose. And the language inside that document felt cold, very cold. I continued reading, then I found a section titled Post-Event Transition Plan. Interesting, very interesting. I looked toward Karen. The color was already disappearing from her face. She knew exactly what I had found. The spectators didn't. Christopher didn't yet. But Karen did. I read silently. The document outlined timelines. Financial allocations, Batrati considerations, account transfers. And then I found the phrase that changed everything after anniversary event announcement. Interesting, very interesting. Because suddenly the party itself looked different, much different. I reviewed the details again, and slowly the picture became clear. The anniversary celebration wasn't being planned to celebrate a marriage. It was being planned to end one. The courtroom became silent, not because anyone else knew yet, because I did. And honestly, even after years on the bench, I still find it remarkable how often the truth hides in paperwork. I look toward Karen Ems Whitmore. No answers. Was this event intended to announce a divorce? The room froze. Christopher turned toward her immediately. Sarah looked stunned. The spectators stopped moving. Karen closed her eyes. Interesting, very interesting, because she didn't deny it. Not immediately, and that mattered. A lot. I asked again, was it? A long silence followed. Then, yes. The courtroom erupted with whispers. The court officer called for order. Christopher remained motionless, absolutely motionless. Years on the bench teach you that shock often looks quieter than people expect. This was real shock, painfully real. I continued reviewing the document. Then I discovered something even more disturbing. The anniversary event wasn't merely intended as a divorce announcement. It was intended as leverage. Interesting. Very interesting, because the financial planning records discussed public pressure, reputation concerns, social expectations, potential settlement outcomes. Everything was calculated, everything. I remember feeling deeply uncomfortable reading it, not because divorce is unusual. It isn't. But because this wasn't about separation, it was about strategy. Christopher wasn't being treated like a spouse. He was being treated like an obstacle. That distinction matters. Then I found David Mercer's role, and suddenly the case became even stranger. David wasn't a financial advisor. He wasn't an attorney. He wasn't a business consultant. Very interesting, because according to the records, David Mercer was Karen's romantic partner. The room became completely silent. I slowly looked up. Christopher looked confused, then concerned, then something else. The realization was arriving gradually, painfully, publicly. Karen lowered her head because she already knew there was no surviving this revelation. Not in that courtroom. I looked toward her. How long? The question hung in the air. Everyone knew what it meant. A long pause followed. Then 2 years. The room froze. Christopher didn't move, didn't speak, didn't blink. Nothing years on the bench teach you that emotional pain often appears in stages. The first stage is disbelief. And Christopher was standing directly inside it. Then I found another section of the financial plan, a section labeled Asset Protection. Interesting, very interesting. I reviewed it carefully, then again, then a third time, because I wanted to be certain the language was extraordinary price transfers, account restructuring, gift reallocations. Beneficiary updates. Everything appeared designed to occur shortly after the anniversary event, not before. After that, timing bothered me a lot, because it suggested the celebration wasn't merely symbolic. It was operational, part of a larger plan. Then I noticed something that made my stomach turn, a handwritten note attached to the document. Only one sentence, but enough. More than enough. I read it once, then twice, then a third time, because I could hardly believe someone would write it. I slowly looked toward Karen. She looked terrified, absolutely terrified, because she knew exactly what was written there. The note read, "Keep Christopher distracted until the transfers are complete." The room exploded. Gasps. Whispers. Shock. Even Sarah looked stunned. Christopher stared at the document as if it belonged to someone else, because in a way it did. The woman described in those records wasn't the wife he thought he knew. And then I discovered something even worse, something hidden in the transfer schedules. Something involving a bank account Christopher apparently never knew existed, an account containing enough money to make the entire $50,000 cancellation fee look insignificant. I have watched countless people react to evidence. Some become angry, some become emotional, some become desperate. But few reactions compare to the look on a person's face when they discover that the life they thought they were living never actually existed. That was Christopher Whitmore. The moment he realized the anniversary gala had been designed as part of a larger plan, something inside him changed. And believe me, everyone in the courtroom felt it. The room was silent. Karen sat frozen. Sarah Collins looked stunned. The spectators were leaning forward so far that several had nearly forgotten they were in a courtroom. And I was staring at a bank account statement that appeared to explain everything. Interesting, very interesting. I reviewed the records carefully, then again, then a third time. Because the numbers were extraordinary. The account contained more than $1.3 million. The courtroom did not know that yet. Karen did. And her reaction told me everything. Years on the bench teach you that people often reveal the significance of evidence before anyone else understands it. Karen looked terrified, not nervous, not embarrassed, terrified. I looked toward her. Mrs. Whitmore, no answer. Would you like to explain this account? Silence then. No. Interesting. Very interesting. Because people usually attempt explanations when explanations help them. Karen had stopped trying. That observation mattered a lot. I held up the statement. This account contains over $1 million. The room froze. Christopher slowly turned toward Karen. Sarah covered her mouth. The spectators gasped. And for several seconds, nobody moved. I continued reading. The account was not new. It had existed for years. Interesting, very interesting. Because according to the financial disclosures submitted during the dispute, the account did not exist. At least not officially. I looked toward Christopher. Were you aware of this account? His answer came immediately. No. No hesitation, no uncertainty, no performance, just no. And honestly, I believed him. Years on the bench teach you how genuine shock looks. Christopher wasn't acting. He looked devastated. Then I reviewed the transaction history. And that is when everything changed, because the money didn't simply appear. It came from somewhere. Repeated transfers, repeated deposits, repeated movements, and the timing was fascinating, very fascinating. Several large deposits appeared immediately after property sales. Others appeared after business liquidations. Others appeared after investment closures. All events Christopher believed had produced much smaller returns. Interesting, very interesting. The deeper I looked, the more obvious it became. The money wasn't hidden from strangers. It was hidden from Christopher. Then I found something even more disturbing. A message attached to one of the transfers. Only one sentence, a short sentence, but enough, more than enough. I read it once, then twice, then a third time because I wanted to be certain. I looked toward Karen. She closed her eyes. That reaction told me plenty. Then I read it aloud. Move it before he asked questions. The room exploded, actual gasps, whispers, shock. The court officer immediately called for order. Christopher lowered his head. And for the first time all day, I saw tears in his eyes. Not dramatic tears, quiet tears. The kind people fight desperately to hide. Years on the bench teach you that betrayal often hurts more than financial loss. Money can be replaced. Trust cannot. Then I continued reviewing the records. And that is when I found David Mercer again. Interesting, very interesting, because David wasn't merely receiving messages. He was receiving money, large amounts of money, repeatedly. The spectators could sense where this was heading. Karen could too. That was why she looked completely defeated now. The confidence from earlier was gone. The laughter was gone. The arrogance was gone. Everything was gone. Only reality remained. Then I found the document that created the viral courtroom moment people would discuss for years. A private letter, never intended to be seen publicly, never intended to appear in court, and judging by Karen's reaction, never intended to be discovered. I opened it, read it silently, then again, then a third time, because even after everything else, I could hardly believe it. I looked toward Christopher, then Karen, then the spectators. Then I began reading. Once the anniversary event is finished, there will be nothing left tying me to Christopher. The room froze, absolute silence. I continued. David and I can finally start our life together. Nobody moved. Nobody spoke. Karen started crying, not strategically, not performatively, actually crying. Because for the first time, the truth was speaking without her permission. Then came the next sentence, the sentence that shattered the courtroom. Christopher still thinks the account balances are real. The room froze again. Interesting, very interesting, because that sentence implied something terrifying if the balances weren't real. Then what was? I reviewed the remaining pages, and suddenly I understood completely. The hidden account wasn't the biggest secret, not even close. The biggest secret was that Karen had quietly moved enormous amounts of marital assets over several years, far more than Christopher knew, far more than anyone suspected. I looked toward Karen, then toward Christopher, then back at the final page, because according to the financial reconciliation summary, the amount involved wasn't $1 million, it was nearly $3 million. And Christopher had never been told. I have presided over cases involving enormous sums of money, millions, tens of millions, sometimes even more. But what stayed with me about this case was never the amount, it was the deception. Because money rarely destroys relationships by itself, lies do. And by the time I reached the final page of those records, it was clear that this courtroom was no longer witnessing a simple contract dispute. It was witnessing the collapse of an illusion. The room remained silent. Christopher Whitmore sat motionless. Karen Whitmore stared at the table. Sarah Collins looked like she had forgotten her own lawsuit for a moment. Honestly, most people had, because the truth unfolding in that courtroom was bigger than anyone expected. I reviewed the financial summary carefully. Nearly $3 million transferred, reallocated. Hidden through layered accounts, moved over several years. Interesting, very interesting, because large deceptions are rarely sudden. They are usually built gradually, one small decision, then another, until the person committing them can no longer remember where the line was. Karen appeared to have crossed that line years ago. I looked toward Christopher. Were you aware of any of these transfers? His answer came immediately. No. Years on the bench teach you that genuine shock has a very specific quality. Christopher wasn't performing. He wasn't trying to win sympathy. He looked like a man who had just discovered that the last several years of his life were based on information that wasn't true. That observation stayed with me. Then I looked toward Karen. Do you dispute these records? A long silence followed. Then she slowly shook her head. No, no excuses, no explanations, no arguments, just no. Interesting. Very interesting, because throughout the hearing, Karen had challenged everything. The contract, the cancellation fee, Sarah's performance, the facts. Now, she wasn't challenging anything. That told me all I needed to know. I turned my attention back to the dispute that brought everyone into the courtroom, Sarah Collins, the event planner. The woman who spent weeks organizing an anniversary gala that never happened, the woman Karen assumed would never fight back, years on the bench teach you something important. Many people who appear powerless are simply patient. Sarah was patient. She preserved emails, comprakt nomes, approvals every document, and because she did, the truth survived. I reviewed the contract one final time. The cancellation clause was clear, the obligations were clear, the signatures were clear, the timeline was clear. Most importantly, Karen knowingly canceled the event after non-refundable commitments had already been made. The evidence supported only one conclusion: the $50,000 cancellation fee was valid, completely valid. I entered judgment in favor of Sarah Collins, $50,000, plus allowable costs payable, direct, supported entirely by the facts. Sarah closed her eyes briefly. Relief, not celebration. Relief. That distinction matters. People imagine winning lawsuits feels triumphant. Often it feels exhausting, because by the time justice arrives, the fight has already taken a toll. Then I looked toward Karen, the woman who entered the courtroom smiling, the woman who rolled her eyes at testimony, the woman who mocked my age and joked about menopause in open court. Interesting how quickly confidence can disappear, because now she sat completely silent, not because she lost money, not because she lost a case, because she lost control of the story. And people who build their lives around controlling narratives often struggle when reality starts speaking for itself. Christopher slowly stood. The room became quiet again. He looked toward Karen, not angrily, not dramatically, just sadly, and honestly, that was worse. Years on the bench teach you that anger often fades. Disappointment lingers. For several seconds, he said nothing, then finally spoke. "You lied about everything." The room remained silent. Karen began crying again, not because she was caught, because she knew he was right. That distinction matters. People can survive financial losses. They can survive lawsuits. They can survive embarrassment. Trust is much harder to rebuild, and trust had been shattered. I later learned that additional legal proceedings followed: financial reviews, exit investigations, questions regarding transfers and disclosures, as they should have. But those matters belonged elsewhere. My responsibility was the dispute before me, and that responsibility was complete. As people began leaving the courtroom, I remained seated for a moment, reflecting. Because some cases stay with you, not because of their legal complexity, but because of the lesson they reveal. Karen believed intelligence meant staying ahead of everyone else. She believed she could manipulate contracts, manipulate vendors, manipulate finances, manipulate her husband, manipulate the courtroom. For a while, perhaps she succeeded. Then one document appeared, then another, and eventually the truth assembled itself, piece by piece. That is what truth does. It waits expectantly until enough facts gather together. Then it becomes impossible to ignore. Years later, I still remember the moment Karen laughed. She thought she was mocking weakness. She thought she was mocking age. What she failed to understand was that experience comes with age. And experience notices patterns. Experience notices contradictions. Experience notices the tiny details people think nobody sees. Karen mocked Judge Judy's menopause in court. She thought it would make her look powerful. Instead, it exposed exactly who she was. And by the time the hearing ended, the $50,000 was the least expensive thing she lost that day, because money can be earned again, cases can be appealed, reputations can sometimes recover. But once people learn the truth about you, that is a debt far more difficult to repay.